Companies Act, Section 469, Power of the Central Government to make rules. Section 469 of the Companies Act, 2013 provides comprehensive authority to the central government for framing rules to support and operationalize various provisions of the Act. Since the Act contains numerous regulatory, procedural, and administrative requirements, this section ensures that the government can create detailed rules wherever necessary for smooth implementation. This provision emphasizes rulemaking as an essential mechanism to fill gaps, provide clarity, and adapt the law to practical needs without repeatedly amending the Act itself. 1. Authority to frame rules for implementation of the Act. The central government may frame rules by issuing a notification in the Official Gazette. These rules are meant to carry out all provisions contained within the Companies Act. Rulemaking supports the Act by providing detailed procedures and compliance requirements that cannot be fully elaborated within the statute. Thus, the government acts as the primary authority responsible for turning legislative intent into operational guidelines. 2. Scope of rulemaking power. The central government may make rules whenever the Act requires something to be prescribed, or allows rulemaking in relation to any subject matter. This includes various administrative matters, procedural requirements, filing norms, fees, powers of authorities, and regulatory compliance obligations for companies and officers. The rulemaking power is broad, ensuring that all necessary and supporting details for functioning of the Act are provided and updated from time to time. 3. Provision for penal consequences. Any rule may specify a punishment for non-compliance. The fine for contravention may extend up to 5,000 rupees. Where the violation continues, an additional fine up to 500 rupees per day may be imposed for each day of continued default. This ensures proper enforcement and discourages neglect of rules essential for corporate governance and reporting discipline. 4. Parliamentary oversight of rules and SABI regulations. Every rule made under this section and every regulation issued by SABI under the Act must be presented before both houses of Parliament. They must remain before Parliament for a total of 30 days, which may span one single session or multiple successive sessions. If both houses modify the rule regulation, it will take effect only in modified form. Reject it, the rule regulation will cease to operate. Importantly, anything already done under the original rule remains valid despite later modification or termination. This oversight process ensures legislative control and maintains a balance of power between the executive and Parliament. 5. Significance of Section 469. It enables flexible implementation of the Companies Act across diverse industries and administrative requirements. It ensures that detailed procedures can evolve with changing regulatory needs without frequent amendments to the Act. It subjects rulemaking authority to democratic scrutiny through mandatory parliamentary review. It ensures rules are enforceable through penalties where required. For more details, contact us.